Now let's discuss the arguments raised by Representatives De Lima and Erice over the 2026 budget with retired Supreme Court Senior Associate Justice Antonio Carpio. Good evening, Justice Carpio. Welcome to The Big Story.
Good evening. Good evening to our viewers.
Justice Carpio, how sound are the arguments raised by the legislators?
Well, they are using the argument advanced by Justice Hernando in the PhilHealth case that the unprogrammed appropriation must be supported by a budget of expenditures and sources of financing, because that's what the Constitution says. And the unprogrammed appropriation is not based on a budget of expenditures and sources of financing, because it depends on whether there are excess revenue collections from certain classes of sources of revenue. No, so that's basically the argument, I believe, of the petitioners now.
Having been a petitioner in that particular case, do you support this petition by Erice and De Lima?
Well, yes, it's the argument raised by Justice Hernando is worth testing, but we will not be filing our own petition, the Sambayan. But if there is a release of funds for the unprogrammed appropriation, that's when we will file a petition. Because under the PDAF ruling, the excess collections must not arise only from dividends from GOCCs, but must come from all classes of revenues, revenues from tax collections, revenues from non-tax sources like regulatory fees. So it cannot just be from one source, no. So we will wait until there is actually a release of funds. But I'm happy that this issue was raised by Congressman Erice and Congresswoman De Lima. No.
Justice, speaking of the 60 billion in PhilHealth funds that was ordered by the Supreme Court to be returned or restored to the budget, were you happy with how they actually did that? Which is because a lot of people are criticizing, they're saying, you know, we paid for it twice because they didn't actually get the original money and restore that, but instead they put it in the budget. What are your thoughts?
Well, it's not the ideal thing that we want. We would have wanted that the source of reimbursement would come from collections from those who run away with the money, those who are guilty of anomalies in the flood control projects. You have this DPWH officials who have been returning funds. We would like the reimbursement to come from such funds, no? If the people involved in these anomalies are convicted, they will be required to reimburse the government. That would have been the ideal source of reimbursement. Only if there is a shortfall when reimbursement from these recoveries from those who were guilty of the flood control scams would not be sufficient. That's when the reimbursement should come from the budget. Because the reason is that we are actually, if the reimbursement is taken from the budget, it's actually us reimbursing, no? Because that will come from our own taxes, and that will be a double whammy on all of us. So, but it's there already. It's already in the law, so we'll just accept it as it is.
What about the 107 billion that they swept from the PDIC? Is the Isang Bayan Coalition also planning to, quote-unquote, go after that?
Yes, we have demanded that the Secretary of Finance and the National Treasurer should return the 107 billion that they took from PDIC, because that's not money of the government, that's money of the depositors. The government is just holding that in trust for depositors. No? So actually, the court has already ruled in the PhilHealth cases that the Secretary of Finance has no authority to transfer funds from GOCCs to the National Treasury to fund the unprogrammed appropriation. But what Secretary Frederick Go said is that the decision in PhilHealth did not order the return of PDIC funds. Of course, the court did not order because PDIC was not a petitioner, or the depositors of the banks did not file a petition. But the underlying reason is the same. In the PhilHealth case, the Supreme Court said that the Secretary of Finance has no authority to transfer funds, trust funds of PhilHealth to finance or to fund the unprogrammed appropriation. It's the same. So if the DOF secretary will not authorize the return, we'll have to go to the Supreme Court and get a specific ruling. It will take time, but I don't know why they don't want to return when it's very clear it should be returned.
Well, Justice, the transfer of funds back is one thing, but what about holding those liable accountable? Those who even made this whole process allow this whole process, especially those who introduced that special provision in the BICAM, in the 2024 GAA, that allowed the government to get excess revenues. Should cases be filed also against them?
Well, there are pending cases against them already, filed by some other organizations, and we will leave that at that. The facts are not yet all in, because we still don't know who actually authored that insertion, that special provision 1D of the unprogrammed appropriation authorizing the Secretary of Finance to transfer supposedly excess funds. No, there are still some facts that have not been disclosed, so we are still looking at that.
Now, moving on to the anti-corruption campaign of the administration and the effort to demand accountability seems to have fizzled out. What is your own assessment?
Again, please.
For instance, the ICC's task is winding down. It's down to just one commissioner. How do you assess the effort of the government to hold those behind the flood control scam accountable? It seems to have fizzled out.
Yeah, I think the Ombudsman has all the powers to investigate this and to file criminal cases against those responsible. We don't need an ICI. That was created because at that time there was a vacancy in the Ombudsman, and people were not too happy with the previous Ombudsman. So, but now I think the incumbent Ombudsman is quite serious in going after the flood control scams, those who are liable for these flood control scams. So I think the investigation should be now turned over to the Ombudsman.
Mm-hmm. Do you still see the need, Justice, for a legislated body to take over the task of the ICI?
Well, actually, there is no need, because the Constitution has empowered the Ombudsman to investigate any official in government. No? He has constitutional authority. What is needed is if he lacks personnel, lawyers, investigators, the Congress should provide the funding so he can hire these people. But in terms of power, the power is all there in the office of the Ombudsman.
I guess one of the issues also, Justice Carpio, is the speed, right? We were so excited, hoping it would be done by December 15 or something big would happen by then. Obviously, if you look realistically, it might be a stretch, right, for courts to move that fast. In your assessment, how long could it take before we could see, a quote-unquote big fish held accountable?
Well, I think the announcement that they would be able to get warrants of arrest by December, by Christmas time, I think that was too optimistic. I think it should come out that those warrants of arrest can be issued either this month or early next month. But December, it was just too optimistic.
Well, it was no less than Ombudsman Remulla who also said that they learned a lesson from that, Justice, na they shouldn't give timelines or deadlines anymore or even name names. So do you agree with that? Is that something they should have avoided to begin with because it created expectations for the public?
Yes, I understand that, but they were also under pressure because the public the entire country was up in arms against these anomalies now, against this scam. So that's understandable, but I think these things don't happen that fast. The justices in the Sandigan Bayan will have to study carefully the information, and they have, before they can issue a warrant of arrest, there must be sufficient evidence also.
Would it make sense also, this was brought up at some point, to make a special division of the court to try those implicated in the flood control mess? What are your thoughts on that, Justice?
Yes, I have suggested that because most of these cases will fall under the jurisdiction of the Sandigan Bayan. And under the rules of the Sandigan Bayan, the presiding justice can request the Supreme Court to create special divisions in case there is a need. So it's up to the presiding justice and the justices of the Sandigan Bayan if there is a need, because they know their dockets. They know if there is a need to create new divisions. But the members of the new divisions will come from existing justices. They will not be appointed. So it's really up to them, no? Depending on their caseload.
Justice Carpio, February is but a month away, and there is that looming VP Sara impeachment round 2. But when can we expect the Supreme Court to decide on the motions pending pertaining to the first impeachment complaint?
Well, we really cannot tell the Supreme Court to decide that. They control their docket. But after February 6, a new impeachment complaint can be filed, whether there is a decision by the Supreme Court or not. So, but of course, if a new impeachment complaint is filed, the issue is whether the House will follow the new rules prescribed by the Supreme Court. And they'll have to decide whether they will accept those new rules already, or they will, whether they will ignore those new rules. And what will happen there is VP Sara will go to the Supreme Court and assail the non-observance of the new rules.
But there is as well a pending case or a complaint before the Ombudsman. So that could also have its own timeline.
Well, the Ombudsman, because VP Sara is an impeachable officer, the most that he can do is to submit his findings to the House for the House to file the impeachment complaint. No? So the Ombudsman, the only role of the Ombudsman is to conduct the investigation and turn over the results of his investigation to the House.
What would be the proper manner by which the House of Representatives should tackle, should there be a second impeachment complaint? The stricter rules that the Supreme Court had made with its decision, or the old rules?
Well, the way I look at it, the new rules will practically kill the impeachment, because there will be a hearing at the plenary level, and that will take time. And what will be conducted at the Senate level will be first conducted at the plenary level in the House. So it's really a redundancy. So I think the House should raise it again in the Supreme Court that if you do this, practically you cannot impeach anyone anymore because of the timeline. Because if you have a hearing at the plenary level, there's not enough time. The Constitution gives the plenary only, I think, if I recall correctly, about 3 session days to submit it to the Committee on Justice. So there's really no time to conduct a hearing.
All right. We have to end it there. Retired Supreme Court Senior Associate Justice Antonio Carpio, we thank you for your time.